Hi, Miss Mizadel.
My name is Samuel, the Lion of Justice. My name is John the Police.
My name is George, the Baby of Fairness.
My name is Preethika, the Lady of Equality.
My name is Ethan, the Prof-in-Law.
Today, we will be presenting about the legal limitations of freedom of speech in Malaysia with reference to the concept of rational legal authority. In Article 10, Clause 1 Para of the Federal Constitution, it states that every citizen of Malaysia is entitled to the right to freedom of speech and expression. However, this right is subjected to the limitations imposed by the Parliament of Malaysia. In Article 10, Clause 2 Para A of the Federal Constitution, it states that the Parliament of Malaysia has the right to impose limitation on the right of freedom of speech if it deems necessary in the interest of national security, diplomatic relationship between Malaysia and other countries, morality or public order and protection privileges of Parliament. Furthermore, according to Article 10, Clause 4 of the Federal Constitution, the Parliament of Malaysia can also by the reason as stated in Clause 2 Para A imposing law to restrict the right of freedom of speech in matters related to right, status, privilege, position, sovereignty and prerogative. In Malaysia, there are several laws which have been imposed by the Parliament to limit freedom of speech based on these provisions. However, in today's presentation, we will be particularly focusing on the Communication and Multimedia Act 1998.
The Communication and Multimedia Act 1998 is a law enacted for the purpose of regulating the converging communications and multimedia industries in Malaysia. Among its provisions are those that limit freedom of speech on digital and multimedia platforms. One of the examples is Section 211 of the Communication and Multimedia Act. In the section, it criminalizes the act of providing any content that is indecent, obscene, false, intimidating, or offensive in character, with the intention to annoy, abuse, threaten, or harass any individual. To add on, this applies to both individual users and content application service providers. Whoever convicted under this section, they shall be liable to a fine of up to Rm 50,000, imprisonment for up to 1 year, or both. Additionally, they shall also be subjected to a further fine of Rm 1,000 for each day the offense continues after conviction. Moving on to Section 233 of the Communication and Multimedia Act. In Section 233 Sub 1 Para A, it criminalizes the misuse of network facilities or services by prohibiting individuals from knowingly initiating, creating, or transmitting any communication that is obscene, indecent, false, threatening, or offensive in nature, with the intent to annoy, insult, abuse, or harass another person. Moreover, Section 233 Sub 1 Para A also covers cases where someone initiates a communication whether continuously, repeatedly, or anonymously with the same malicious intent, regardless of whether a response ensues. Upon conviction, according to Section 233 Sub 3, the offender shall be liable to Rm 50,000 or to imprisonment for a term up to 1 year or both. In addition, he shall be subjected to a further fine of Rm 1,000 for each day the offense continues after conviction.
Moving on to the 3 cases that illustrates how the Communication and Multimedia Act 1998 limit the right of freedom of speech in Malaysia. For the first case, it is the case of Muhammad Fahmi Reza against Pendakwa Raya. In this case, the appellant was charged and convicted under Section 233 Sub 1 Para A of the Communication and Multimedia Act for posting a photo on Facebook with the intention to hurt others on February 8, 2016. This is the photo. The Session Court convicted the appellant, and the High Court, in this case, later upheld the conviction but reduced the sentence to a Rm 10,000 fine, and if he failed to pay, he will be serving 1 month imprisonment. In this case, the appellant, in his defense, argued that the said posted photo was a parody and that it was a political satire to criticize the authorities for restricting freedom of expression and the internet. In response to this, the court held that the appellant having a view that the authorities are restricting freedom of expression and the internet is unguilty. However, when the appellant had expressed such view in the form of communications, as prescribed in the law, such act cannot be said not conflicting the law. To add on, the court also stated that parody must not be produced with the intent to injure others. If does, it doesn't fall under the meaning of parody. Therefore, the court further held that the communication of the appellant is a communication that violates the provisions of Section 233 sub 1 para A of the Act.
Moving on to the second case, it is the case of Nick Adib bin Nick Matt against the public prosecutor. In this case, the appellant had been charged and convicted by the Session Court for an offense of posting pictures that was titled Pesta Bogel and contained obscene element regarding certain leaders on Facebook which were offensive and false under S233 sub 1 para A of Communication and Multimedia Act. Dissatisfied with the judgment, the appellant appeals the judgment to the High Court. In this case, the High Court affirmed that the offense falls under the following section, which is considered as a cyber offense, is a serious offense due to the fact that offensive materials could be easily disseminated to the public at large within seconds at a touch of a button. However, the court had taken into account that the appellant had repented and regretted his actions, as well as the fact that he has many children to take care. Not just that, he is the sole breadwinner of the family and had lost his present job as a teacher. Furthermore, this is the first time the appellant had committed an offense. Therefore, the High Court mercifully accepted the appeal of the appellant, substituted his punishment from Session Court with 1 week imprisonment and a fine of Rm 3,000 and default 3 months imprisonment.
Lastly, the third case is the case of Pendakwaria against Muslim bin Ahmad. In this case, the accused was charged for each posting of 3 offensive comments on the Perak state government's official portal under Section 233 sub 1 para A of Communication and Multimedia Act. The 3 offensive comments are "Damn your Sultan Kantoi," and "What's the Kantoi with your Sultan?" The High Court in this case held that these 3 comments were extremely offensive, thereby sentenced the accused of a fine of Rm 10,000 in respect of each charge, and in default of each fine, to 6 months imprisonment.
In conclusion, it is fitting to end with the words of our former Prime Minister, Tan Dr. Mahathir, in where he said freedom of speech is not a license to abuse, it is a responsibility. Freedom of speech without any concern for good human behavior would be a disaster for any society. In Malaysia, statutory legislation like the Communication and Multimedia Act has explicitly drawn up the boundary between freedom of speech and statements of harm. This have effectively ensured the right of the citizens to express their dissatisfaction and opinion, while protecting Malaysia's religious harmony and public order.
That's all for us. Thank you.